Here's what you need to know about State Personnel Board pre-hearing and settlement conferences. Hi, I'm Brett Sherman with Goyer, Rano, and Thompson. If you find this information useful, make sure to hit those like, subscribe, and share buttons. The first question you may have is, what is a pre-hearing and settlement conference? A pre-hearing and settlement conference, also shortened down to a PHSC, is a time where the parties and their counsel, if they have one, meet with an administrative law judge, otherwise known as an ALJ, from the State Personnel Board in an attempt to potentially resolve or settle the matter before the State Personnel Board. 12 calendar days prior to the PHSC, the parties are required to serve upon the State Personnel Board and the opposing party a PHSC statement. This statement contains a multitude of items which are required to be filed with the PHSC. Such matters within there are, first, if there are any other cases or complaints or matters that have arisen out of the same transaction or occurrence, which is before the State Personnel Board. A lot of times this may come into play where there are multiple people disciplined over the same matter and they may have separate appeals before the State Personnel Board. In that case, the matters may be consolidated. The next thing that's listed is whether or not there are any affirmative defenses. Sometimes these come up as, for instance, if the employer has blown the statute of limitations in order to bring a disciplinary action, or there's a belief that the disciplinary action is taken for retaliatory reasons or as a form of harassment or whistleblower. Facts aren't required to be stipulated between the parties. However, if there are facts that are stipulated, the State Personnel Board wants to know that so that they can put it on record as stipulated facts. The parties will also do their best to estimate the time it may take to hear the matter. The reason for this is that should the matter not settle at the PHSC, the administrative law judge will set the matter for a hearing and use the parties' estimates to schedule the matter. Another thing listed in the PHSC statement is a list of all potential witnesses which the party may call at the hearing. Now, this is an absolutely crucial step to the PHSC statement. The parties must list all witnesses who may be called at the hearing. It doesn't mean the parties are required to call all witnesses who they have listed in their PHSC statement. However, in order to call a witness, that witness must be listed on the PHSC statement. The only exception to this is if a witness is called for impeachment or rebuttal. Along with that witness's name, the parties must list what they believe that witness may testify to. Now, why this is so crucial is that if a party does not list a potential witness in their PHSC statements, the State Personnel Board can prohibit that party from calling that witness if and when the matter proceeds to a hearing. Now, sometimes a witness to the matter may be an inmate. If there is an inmate who is a witness to the matter or may be called as a witness, those inmates need to be listed separately on the PHSC statement. Similarly, if a witness that is potentially going to be called is an expert witness, those expert witnesses need to be listed separately, along with a brief statement of the opinion each expert may say and a copy of their resume. Along with listing potential witnesses, the parties must also list potential documents and exhibits that are to be introduced at the hearing. Now, similar to listing of potential witnesses, if a party does not list potential documents or exhibits, they may be precluded from introducing those documents or exhibits at a hearing. And just as potential witnesses, documents or exhibits which are for impeachment or rebuttal purposes do not need to be listed. The parties will then list a concise statement of any significant evidentiary issues which may assist the ALJ in conducting the hearing. And lastly, the parties will provide any dates of unavailability for parties, counsel, or witnesses. The reason for this is that if the PHSC does not result in a settlement, the ALJ will use this unavailability to set the matter for hearing. Did this video clear up any questions you may have had? If so, please make sure to hit those like, subscribe, and share buttons. Lastly, it's important to know that appearance at the PHSC is mandatory. Should either party not appear at the PHSC, the matter shall be deemed withdrawn unless it is continued for good cause. Thank you for watching this video. I'm Brett Sherman with Goyer, Rano, and Thompson. If you or anyone you know needs assistance with the PHSC or the State Personnel Board matter, please do not hesitate in giving us a call or hitting the link below and filling out the form.